I want to turn now to the divorce space because two things I've seen happen. One, in the middle of a case, one of the parties became incapacitated. They could no longer handle the process themselves. So then I have to call you and get a conservator, typically. Is that accurate?
Yes, that is accurate. If that person does not have a power of attorney and they haven't already designated an agent to act in their stead in their incapacity, then someone's going to have to come into court and act in their stead, which is interesting because the if it's in the middle of a divorce, the the uh, the living spouse is still considered the spouse, and that living spouse still has an interest in becoming the conservator. Courts probably won't do it, but they can certainly ask. And so that's where, again, estate planning is so important because you avoid what is already a very complicated situation because now that that person doesn't have capacity, then you want to make things easy for your successors and interests so that they can jump in as your successor in the event something happens to you. So you want to avoid a conservatorship by having a power of attorney. But if you don't, then you are definitely going to need to, someone's going to need to come into court and have the court make a determination, appoint someone to act in your stead in the capacity as a conservator.
Yeah, in this particular case, her daughter stepped in. So at first, husband did try to
Mm-hmm.
be in, but clearly there's a conflict in the divorce, and then the probate court did not feel comfortable, and her family clearly fought it.
Mm-hmm.
But to your point, I think it's very important once you start a divorce, anything can happen, car accident, surgery, whatever, to make sure you appoint someone in the event that something happens. Divorces can take 1 year to five. So we're not hoping something happens to you, but I think it's important to prepare in the event that you become incapacitated.